Right, sir?
Correct.
Okay.
Yeah.
Okay. Aditya, let's begin then.
Sure, Nitik. Good afternoon, everyone. Welcome to the fifth lecture of Compass 2020. With the lockdown having arrived with unprecedented challenges testing the mettle not just of the students, but also of the entire education system, we believe that as a part of our effort to provide an enriching learning experience to the larger student community, and we've come up with a unique lecture series called Compass. We'll be inviting a diverse range of luminaries who will be sharing their insightful knowledge and experiences on various topics with all of us. Firstly, I would like to express our heartfelt gratitude to our principal, our vice principal, to the director of Internal Quality Assurance Cell of Hindu College, and the teacher in charge of caucus, without whom this event wouldn't have been possible. Over to you, Nitik.
Uh, Now, let me express gratitude on behalf of Hindu College and Caucus to Sir for joining us today and taking time out from his busy schedule to address us in this series. We understand that not everybody is as has similar opportunities as us. For those who cannot join us today via the Zoom video call, we have a dial-in facility where they can join the audio from the phone. We also have a live stream via YouTube and Facebook where people with low bandwidth can join us. Those who cannot join us due to internet connectivity today, we have for them a transcript which will be published at the end of this session on our blog, and they can access it via the blog caucusdiscussions.wordpress.com. During these tough times, we also urge you all to consider donating to organizations like Akshay Patra, Feeding India, Oxfam India, and Doctors for You so that they can continue with their good work. Now, I call upon Tanishk to set the agenda for the day with his brief PPT. Tanishk, over to you.
All right, so I'll be giving a brief presentation on today's topic, that is judiciary and judicial reforms in India. So firstly, the structure of the judiciary. It is an integrated judicial structure in a hierarchical order with the Supreme Court at the top, and below the Supreme Court are the high courts of the state, and below them are the subordinate courts which we approach for our day-to-day jobs and other kinds of issues. So moving ahead, whenever there is a dispute between the federal units of our country, for example, the center and the state, these disputes come under the original exclusive jurisdiction of the Supreme Court. The power of the Supreme Court to overrule any decision by one of the lower courts is known as its appellate jurisdiction. The power of the president to seek any kind of advice on any legal matter by the Supreme Court is known as the advisory jurisdiction. And finally, the power of the Supreme Court to go ahead and review any one of its decision on the account of any kind of error that might have perverted the decision or any kind of new evidence which might change the course of the decision is known as review jurisdiction. Now, the appointment of the judges to the Supreme Court is done by the President of India after consultation with the Chief Justice of India and other Supreme Courts and the High Courts of the states. However, the term consultation has come under different kinds of interpretations throughout the course of India's judicial history. For example, in 1982, the judiciary first said that the president's view on this matter would be final. In 1993, it reversed its decision and said that the consultation of the Chief Justice of India on this matter would be final after an advice by the other two senior most judges of the Supreme Court. However, in 1998, the Supreme Court adopted the collegium system, wherein there were four senior most judges of the Supreme Court who made the matters of consultation in this particular matter. However, in 2014, the collegium system was disbanded and it made way for the National Judicial Appointment Commission, or the NJAC as we know it. However, again in 2015, the NJAC was disbanded and the collegium system was restored. The judiciary held the view that the independence of the system was being compromised under the NJAC. Moving ahead to Chief Justice of India, the senior most judge of the Supreme Court is appointed as the Chief Justice of India. However, this appointment process has been filled with some of the controversies in the past. Let us look at 1973, when Justice A.N. Ray was appointed as the Chief Justice of India after superseding three senior most judges of the Supreme Court. Similarly, in 1977, H.R. Khanna, who was the senior most judge of the Supreme Court at that particular time, was superseded by M.H. Beg, who was junior to him, and this led to another controversy, and he became the Chief Justice of India. And finally, master of the roster controversy of 2018, wherein 4 senior-most judges of the Supreme Court held their reservations in a press conference against selective allocation of politically sensitive cases to select benches. Now, moving ahead, several reforms have been suggested throughout India's judicial history, and these have been mainly done in Law Commission reports of India. Other substantial reports include the G.K. Raskin report of 1925, Justice S.R. Das report, Justice V.S. Malimat report, which has been pretty landmark in this particular case. It also held the view that the existing criminal justice system weighed in the favor of the accused and did not adequately focus on the justice of the victims. Now, let us look at some issues which are usually talked about when it comes to reform in the judiciary. We have pendency. More than 300 crores are pending across different branches of the judiciary. We need alternate dispute management mechanisms in order to reduce this pendency. We also have faced a lot of delay in the Supreme Court, which is not only, and different courts, which is not only monetarily taxing, but also mentally taxing for those involved in the litigation. Then are problems of judicial ethics, for example, corruption, favoritism. And finally, one of the most important problems is the loss of trust and faith in the judiciary. This can be highlighted in the Hyderabad encounter, wherein several media houses reported that the steps taken by the state machinery and police resulted in some fatal consequences. Now, let us look at some of the recent developments related to the judicial reform. The All India Judicial Service is a suggested reform, which is a pan-India level examination in order to admit officers to lower and subordinate courts. Similarly, a permanent constitutional bench was set up in 2019 in order to deal specifically with matters related to the Constitution as well as matters associated with the Constitution. Finally, we also see the celebration of the tradition of dissent in the Supreme Court, wherein in the 2017 privacy verdict, 3 great dissents in the history of the Supreme Court were celebrated. This also included Justice H.R. Khanna's dissent in the habeas corpus case, wherein he opposed the governmental view that fundamental rights such as right to life and liberty can be curtailed during an emergency period. It finally held the view that dissent is a reaffirmation of fundamental rights in some cases when the Supreme Court itself fails to protect them. And finally, we see the Ram Janmabhoomi Babri Masjid verdict. Several people have called out the court by saying that this has been a balancing act between faith. People have also criticized the court for prioritizing faith over rule of law. Also, another fascinating aspect of this judgment has been the anonymity of the judge who wrote the verdict. One of the judges also gave different reasons for his judgment in a 116-page addendum. His identity has also been held anonymous. This specifically raises 3 questions. Why did this happen in the first place? Secondly, what are the implications of this particular thing on different kinds of further cases which might come up? And finally, what are the implications in the overall judicial system? I would like to conclude by giving a quote by French thinker and writer André Gide. Everything has been said already, but no one listens. Hence, we must always begin again. This is similar in the judicial reform sector as well. Instead of now talking, the time is for action. Thank you so much.
Thank you, Tanishq. Let me just briefly introduce Sir. Thank you, Tanishq. Let me just briefly introduce Sir before we hand over to him. Sir, who has most recently been appointed as Her Majesty's Counsel, got invited to the Blackstone Chambers in 2013. He was the Solicitor General of India from 1998 to 1999 to 2002 for 3 years. One of his most pioneering cases was the Balco case and also the anti-dumping case in the Supreme Court. Apart from that, he's also a recipient of the most coveted award, one of the most coveted civilian awards in India, that is the Padma Bhushan. And most recently, he was in the press for the Kulbhushan Jadhav case, where India managed to get a provisional stay on hanging of Kulbhushan Jadhav. Sir, without any further delay, over to you. The floor is yours.
Good afternoon, and it's always a pleasure to share ideas, interact with young friends. And one of the subject which you've chosen for today is one of my favorite subjects for the reason that, first of all, there is a lot of confusion about what exactly is a court in India. And there is, of late especially, a lot of criticism about the way the courts work. And the criticism stems more because people do not understand what is a constitutional court and how it is supposed to work. The second also is, which is very dear to my heart, is trying to fix the problem of judicial arrears. I have always worried about India reaching a point where people lose complete faith in the judiciary. They say justice delayed is justice denied. In India, justice is so delayed that it becomes almost a mirage of justice. And it becomes at times irrelevant. And this is very worrisome. And this needs to be sorted out. I will touch upon it, it has led to a complete distortion of our criminal justice system. Thirdly, appointment of judges. Because I feel now this has to be a people's movement by which we have to fix an aberration which has crept into the system. These are three broad issues I propose to touch upon and exchange ideas with all of you. Let's first start by understanding what is the Indian legal system. As you know, when India was born in 1950, 26th of January 1950, as a republic, the constitution which we gave to ourselves was a mix of various different systems. In governance, we adopted the Westminster model. We didn't go for the American presidential model. But we also adopted a quasi-federal system. Now, why do I call it a quasi-federal system? Because in America, the states are sovereign in their own rights, except for the area carved out for the union or for the federal government. In India, it's the other way around. It's the union which is sovereign with power carved out for the states, and all residuary powers vest with the union. The second is the interplay between the union and the state laws. We did not follow the Canadian model where both could legislate on the same subject, and to reconcile which the Canadian Supreme Court had to come up with what is called the aspect theory, to say one could legislate on one aspect and the other could legislate on another aspect. We did not follow the American model, in which the federal government has demarcated subjects and everything else is with the state. We came up with a different model where we created two lists, which were the exclusive lists. We created a third list, which was the concurrent list, with an overriding power for union legislation. We call it a quasi-federal constitution. The Indian judiciary, however, is a unified judiciary. So every court and the subordinate courts up to the High Court, that is why the structure is a two-tier structure. You have the High Court and the subordinate courts. And the word subordinate courts means subordinate to the High Court. The High Court has supervisory power over all these courts. Judicial supervision, administrative supervision. The High Court and the courts below are the state courts. The Supreme Court is the federal court, but the judiciary is unified. So every judge, be it a judge of the lowest possible court or be it a judge of the High Court, or be the judge of the Supreme Court, every judge, when he deals with legal business, he doesn't demarcate between federal laws and state laws. The state laws, the federal laws are administered through the same judicial system in the states as the state law. And the Supreme Court of India has complete appellate jurisdiction over courts, irrespective of the law which they have considered. So if the state, if a question arises under a state law, the question of law arises under the state law, the Supreme Court lays down the law. That's very important to recognize. When we talk of an all India judicial service, and a lot of people criticize it, saying you're going to break away the states. I think it's a wonderful idea to have an all India judicial service. I have been a protagonist of the all India judicial service. And I feel it's a good idea to have a properly structured all India judicial service. Because if the judiciary is unified, then I don't see any reason why the cadre of the judiciary, like the Indian administrative service, should not be unified. The Supreme Court, and to an extent the High Court, however, are unique. The Supreme Court, apart from being a court of appeal, the last court of appeal, is also a constitutional court. It is a constitutional court because the Supreme Court is the sole judicial tribunal which can decide federal disputes. Federal disputes are of two kinds. Federal disputes are disputes between states or disputes between the union and the states, or any mix of these two entities. The only court which is competent to decide this is the Supreme Court. The second, a subset of the first, is water disputes, where Parliament can by law create a specialized tribunal, to which extent the court loses jurisdiction. Other than that, the Supreme Court has complete jurisdiction. So that's a very important role which was cast upon the Supreme Court. The second is the Indian Supreme Court, by the founding fathers of our Constitution, was expressly made the guardian of the constitutional rights. The High Court are constitutional courts. In fact, all courts in India, definitely the constitutional courts, the High Court and the Supreme Court, have the right to decide not just upon the legality of administrative action, but they also have the right to decide about the constitutional validity of legislation. So we did not, unlike the American Supreme Court, we did not have to invent, as they did in Marbury Madison, as this famous American case where the Supreme Court is conscious of the fact that it is a constitutional court. And being a constitutional court, whose edict is binding on everybody, the court always has to be conscious of what law they are laying down. I remember the youngster, I was sitting in the court, Chief Justice, Senior Chief Chandrachud was Chief Justice that time. And he was rejecting an argument which we thought was pretty good. And he says, no, we do not agree. And then he told the lawyer, he says, we have to hear the unheard voices and see the unseen faces. As a youngster, I thought that was rather unfair because the judge is thinking of maybe there is some argument there in stratosphere which defeats my point, and why is he throwing our point out? What he really meant was that when the Supreme Court lays down law, they have to see so many dimensions. The word, the text of the law is only one of them. The effect on public interest. How is it compatible with the system? Is it compatible with our constitutional values, that construction? All this goes into the mix. The second thing, which a lot of people don't understand, who are not familiar with the system, and that is why we've heard of a in recent times, especially a lot of criticism about the court failing to do its duty, the court failing the Constitution. Every court, every constitutional court, be it the US Supreme Court, be it the Supreme Court of India, be it now the Supreme Court of UK, has a very important condition. They have a discretion on which case to decide, unlike other courts. Why? It is because every constitutional court has to decide which issues it wants to take on board. I had a very interesting discussion once. I was in Washington as a part of the Indo-American Indo-American Legal Forum. And we were sitting with Justice Sandra Day O'Connor, one of the senior most US Supreme Court judges. And she was saying we get about 5,000 to 6,000, they call it writs. You file a petition for certiorari to set aside the decision of a lower court. She said we get about 5,000 and we entertain 100 to 200. And we saw in her chambers stacks and stacks of papers. And she says we read these with the assistance of our law clerks and decide which ones to admit and which ones not to admit. They don't even hear lawyers at that stage. And as she explained, she said, look, for us also, we have to see, A, does it raise the constitutional law of such importance that we should be deciding it? And secondly, is the time right to decide that issue? So where it came to desegregation of colleges, the question of abortion, we hear of the US Supreme Court, Roe and Wade. We don't hear about how many petitions came before that and were declined. The court waits for the right time to decide a controversy. And this is inherent to the working of a constitutional court. You file an appeal in the UK Supreme Court, you don't get a hearing. It is decided on papers. And the court sees what is this question of law you want to bring before them, and is it important enough, and is it really for them, and is it the right time to decide that question? So when the Indian Supreme Court on many times, initially, it said, we are not taking on the migrants problem. It was not the court running away from its constitutional duty. It was the court holding back at that moment. Later on, the Supreme Court has suo moto picked up the issue and is deciding it. So when we criticize the court, please understand it is always a very delicate choice of the causes which the court wants to address. And hindsight in law, as in everything else, is always 20 by 20. We can always turn around and say, you made a mistake, you should have decided it first time over. But all decisions which are taken in the sense of trying to balance. And this brings me to the next issue, which you touched on the opening, the appointment of judges. What happened? The Constitution, the words of the Constitution did not change. The Constitution still says that the President shall appoint judges in consultation with the Chief Justice. If it is the Supreme Court, Chief Justice of India, if it is the Supreme Court judge, and in consultation with the Chief Justice of India and the Chief Justice of the High Court, if it is the High Court judge. A system had evolved traditionally by which for a High Court, the High Court Chief Justice would send a recommendation to the Chief Justice of India. And he would normally consult his two or three senior colleagues. And he would send the recommendation. And the Chief Justice of India would discuss it with his two or three senior colleagues and discuss it with the law minister. And in the consultation, the law minister would ask the Chief Justice would send names, the law minister would select from them. If the government had any problem, they would come back to the Chief Justice and the whole matter would get resolved. And the first problem came when Mr. Shiv Shankar was the law minister. And we fought very hard. The first judge's case, really. The first one was Sakaltan State in emergency. Let's not talk about it. the first judge's case, S.P. Gupta, where we were all very angry because of two things which were done by the government. Believe me, up till that time, the selection of judges was not a serious issue. By and large, the selection of judges had been uncontroversial. The two issues which were before us, one was the power to transfer judges. Now, everybody was very concerned because this was 1980. It was the same political party, i.e. Congress party, Mrs. Gandhi had said, who had in emergency transferred judges around who were inconvenient. So when the proposal was that the Chief Justice, that every judge who is sworn in must accept that if he is transferred, he will not resign in protest, was seen as an advanced compromise, which the judge has to enter into. He has to virtually promise that he will be nice, otherwise he'll be kicked out. That's how we read it. And the second was about appointment of additional judges, saying whenever you appoint a judge, appoint him as an additional judge, and then he'll be confirmed after 1 year. So we said a judge on probation is alien to the Indian Constitution. We fought the case, and believe me, whatever the Supreme Court may have held, it is the Chief Justices of the Supreme Court which have ultimately brought this system into play. Yes, you don't have to sign a piece of paper saying you agree to a transfer. But the Supreme Court transfers judges, and some of their transfers have been highly questioned. It only shows that this power of transfer is a very dangerous power. Doesn't matter who exercises it. We now have a tradition that whenever somebody is sworn in as a High Court judge, he comes in as an additional judge. Why? Because the power of removal is so difficult. It's almost a status of irremovability. So you see a person's performance for a year as a judge, or 2 years as a judge, and then you appoint him. And this is a system now which the court itself administers. And the third is we have now a almost inflexible rule that a Chief Justice is from outside. So it was in this background that the first judge's case came to be decided. By the time we drifted into the second judge's case, things had changed a lot. Like Mr. Shiv Shankar told me when Senior Chandrachud was chief and he was the law minister, he said, how did we appoint judges? He said, we used to meet up for a coffee and discuss. And he said, if I had a problem, I'd tell him that, look, chief, these are the objections we have to your names. And he said, we used to resolve it. So theoretically, while I was only consulting him, he said I don't remember a single case where we had a disagreement in which I had to override him. That's how the system works. That's how all efficient systems work. By 1990, everything had changed. The way judges were being appointed had changed. The political interference had become such that the judges were feeling suffocated. So what did they do? The same very words were given a completely different construction. We brought in the principle of the silence of the Constitution, and where the principle that certain practices and precedents become almost enforceable constitutional principles. And whether the reason was right or not, everybody was agreed that the conclusion was right, that the judges must be appointed by judges. We worked that system. We worked that system from 1990 till 2000, and there was great disaffection for the way the system worked. In fact, Justice Verma, God bless his soul, Justice Verma, one of our towering personalities as judges, he is reputed to have said once, he was the not just the author, he was the motivating force behind yanking away this power of appointment from the executive. He's reported to have said that if I knew this is how it's going to work, maybe I would have had second thoughts about laying down this law. Evolution is very important in constitutional law, and I think the government came up with a very good model of the National Judicial Commission. But then, and I make no bones about it, it became a turf war with the court. And the court sat and decided that this NJSC eroded power. And there is a premise which I seriously contest. The premise of that judgment is that if judges don't appoint judges, the judiciary will lose its independence. What about from 1950 to 1990? We had some of our most powerful judges which came from that flock. Justice Krishna Iyer, one of the greatest jurists ever, was from that flock. Justice Chinappa Reddy, Justice Chandrachud, Justice Bhagwati, Justice Tuldapurkar, Justice Pathak, they were all appointed by a system prior to the judges taking over the power of appointment. So this kind of an argument is unconvincing to somebody who's familiar with the system, and we need to correct. And I think this will now be corrected only where it becomes a public movement. How do we resolve the pendency issue? On a very simplistic basis, the pendency issue is a problem of demand and supply mismatch. If you see countries where the system is extremely efficient, in Australia, every few years they do what is called spring cleaning, and they consider cases which are 1 year old extremely old cases, for which they put up for settlement, saying, oh, it's a very old case, it's 1 year old. I think we need to find some way of mediating this case, because cases should be resolved in 6 to 8 months. Start to finish, I'm talking of trials. Look at the Enron trial, within 2 years, such a complex trial, so many indictments, so many different dimensions, start to finish, people are in jail in 2 years. Why is it that they are able to do it and we can't do it? It's simple. Judge strength is measured by number of judges per million people. There are countries with 100 judges per million. I think US is close to 100 judges per million. The UK has 50 judges per million. UK is very different. In UK, the pendency is increasing because of more and more international cases coming. It's a very interesting statistic. A couple of years ago, somebody analyzed. Out of 100 cases decided by the UK High Court, only 20 have 2 British parties. 80% cases have at least one non-British party, and of them, at least half have no British party involved. So it's become an international dispute resolution court. So that's why their pendency goes up. And here when you talk of pendency, they say horrible pendency, a trial is taking 1 year. In 1 year, we barely warm up for a trial in India. So this is the problem in India, and why? I think our sanction strength is 20 judges per million. We are hovering somewhere around 14, 15 on last count. Today, we have reached a position where subordinate judges are advertised. Judges are advertised. People are not taking up jobs in judgeship. Why? Because our salaries are abysmally low. Abysmally low. Come to the big cities. If you're going to pay a judge, I know what sacrifice it involves. I pushed my own nephew into judgeship. And he's a judge and he's doing very well in Delhi High Court. And I know how much persuasion it took to get him. He had become a silk. He had a very lucrative practice. But he had the sense. Now, you cannot hope that everybody, all successful lawyers will have that great sense of sacrificing, all right, for my country, I will do it. You have some people who do it. You have Justice Nariman, who had a very flourishing practice, who happily became a Supreme Court judge. You have Justice Nageshwar Rao, who agreed to become a Supreme Court judge. You have Justice Lalit, who agreed to become a Supreme Court judge. You have Justice Indu Malhotra, who agreed to become Supreme Court judge, who all gave up lucrative practices. But these are few and far between. The numbers you need are the numbers of the subordinate judiciary. And at that stage, when you are a youngster and you are wanting to opt for a career, why will you go for a career which is so completely low in salary? And remember one thing, in civil service, you join as a collector after doing your IAS. You move up the ranks, you move from the union, from the state to the union to the state, you get promotions, you get promotions right up to the director's level. Then you're in the union civil service, and from director, you become joint secretary, additional secretary, secretary, and so on. What do you do as a judge? You become a subordinate judge. You're a junior subordinate judge. You become a senior subordinate judge. And you become a super timescale subordinate judge. And you keep deciding exactly the same cases. So you need a completely different pay structure. And we have to make jobs for judges more and more attractive. And here the government fails completely. A long time ago, I remember Arun, God bless his soul, Arun Jaitley and I, we were both at the bar. And the Supreme Court asked us, there was some dispute about some rooms being made available to the judiciary in Tisazari. And the case was in the Supreme Court. And he said, both of you go and have a look at what the government is offering and whether the request is fair. And we went there. And it is remarkable. The room of the executive district magistrate and the room of the judicial magistrate were a study in contrast. The executive magistrate had a plush chamber with an air conditioner, and the judicial magistrate had broken chairs, broken tables. Believe me, for those of us who work in the Supreme Court but once in a while go to the trial court, we are not surprised at the output. In fact, we are surprised that even there is this much output. There was a study which one of the American judges gave us, where they said if you put 3 cases before a judge, he will try and finish all 3 in a day. If you put 6 cases before a judge, he'll finish 2 out of the 6. If you put 25 cases before him, he'll know you're not serious. He doesn't care even if he finishes 1, because in any case, he's not supposed to finish his work for the day, right? Go to a magistrate's court. They have 60, 70 bail applications. You're done by the time you've heard 60 bail applications. You don't have the mental space left to decide anything more serious after that. So we have to fix this system. And believe me, fixing the Supreme Court, fixing the High is not as important. You have to fix the High Court. You have to fix the subordinate judiciary. You need more numbers. Point number 1. Point number 2, the government has to sort itself out. The same government which doesn't make resources available for the judiciary is the single largest litigant. Why? Because nobody in the government wants to take a decision which does anything good for the citizen. I always sometimes joke, I say, what is the reason why you people are like this? Is it that when you join civil service, you're given a fat, beautifully bound book which says 10,000 ways of saying no? Why is it that so many citizens are driven to court for small things which they need from the government? Because nobody wants to decide. And you're told, go to court, फैसला कोर्ट से करा लो, हमारे को छोड़ दो. This has to change. The government of India makes laws which are so powerful in the area of arbitration. But see where a government department is involved, see how they behave in an arbitration. And I'm saying so publicly, I'm involved in a very important arbitration, which in Parliament was criticized, saying, why is it taking so long? And the arbitration is being held in India. We have a very eminent panel of former Chief Justice, Australian former Chief Justice, retired judge of the Court of Appeal, very big arbitration, large stakes involved. They directed the government of India to produce certain documents. They took it all the way up to Supreme Court and delayed it by a year. So it's all very well to make powerful laws dealing with arbitration and trying to find alternate dispute resolution, which is a must. You must have the spirit, the right spirit in which you work all this. So we need efficient justice to be a public movement. The reason is politicians do what gets them votes and what is important in public consciousness. Unless quick justice and removing pendency in courts becomes a political issue, this is not going to change. That is my firm conviction. The working of the court. Should we have permanent constitution benches? Certainly not. let the court run itself, let them decide what they want to do. I think our Supreme Court has had a sterling record, but for two major incidents. The first was the emergency judgment, which was deeply flawed in law, it was completely wrong in law, and a complete abdication. Little surprise that there were hardly any issues in that judgment which came up for consideration before the 11-judge bench had heard the privacy case. 9-judge bench has heard the privacy case, but they overruled it, and thank God they did, because the Supreme Court had to publicly once say that they were wrong, and they buried it deep. Justice Cole, I think, used the word 50 fathoms deep. The second blot on the Supreme Court is the press conference. How the court works itself has to be a matter which the court must decide for itself within its confines. The meaning of having a press conference, of informing people outside a complaint against your own Chief Justice, is inviting external interference into the court. What did the court want? That the government intervene? That the government set the agenda for the court? What happens to judicial independence? What is the meaning of a press conference? Is it only to embarrass a colleague? Or is it to invite outside interference into the working of a system? And believe me, if there is a shortcut to winding up independent courts, it is by inviting outside interference into how a court functions. And all this done for what? For the Loya case, because it was put before a particular judge. I think you should read Justice Chandrachud's judgment in that case, what sort of a case that was, and how it was finally decided. And I think my criticism of that press conference will be more than justified. So our court has done a wonderful job. It has selected causes, it has decided causes, it has at times become proactive. Some of its judgments have cost us dearly. There have been big mistakes. I think the 2G case, where all telecom licenses are cancelled, the coal case, the Goa mining case, the Andhra mining cases have not done the Supreme Court proud. It has put the country in a very difficult situation. And there is a degree of course correction which is going on, which happens in every institution. It happens in every institution. And I think our institution is going through that. And lastly, the Ram Janmabhoomi anonymity. I think it is naive to pretend that while deciding the Ram Janmabhoomi case, the Supreme Court was not conscious of its overtones. I remember when the first Ram Janmabhoomi judgment came, Justice Verma was on the bench, where they appointed a receiver and construed the statute as making the government the statutory receiver, laid down the law, struck down the acquisition of the land, etc., etc. When the first judgment came, the first Ram Janmabhoomi judgment, Justice Verma said, he says, I never cared about what judgments I deliver, but he says, when I delivered this judgment, at the end of the day, he says, I was hearing the news, I was so worried, I hope there are no more riots in India. So there are times where the court is conscious. The court is perfectly conscious that one of the two sides in the Ram Janmabhoomi case will lose. And the case has evoked such passion and has become such a political horse which everybody wanted to ride on, that there will be criticism of the court. And people will try and attribute motives, will say, Judge so-and-so held this, but Judge so-and-so held it, and why did Judge so-and-so hold it? I think the Supreme Court rose above its normal practice and delivered a unanimous judgment is a remarkable tribute to the way the court can rise to the occasion and deal with matters. And believe me, it was a unanimous judgment. There were inputs given by all judges on what should be decided. Each of them gave an input. There was no single author of the judgment. They put it all together and they delivered it as a unanimous judgment. So I don't find anything to criticize or to create a cloud about in the unanimous judgment. We have a wonderful judiciary. It's been, as I always say, yesterday we were on a debate about whether India has failed its founding fathers. And I had only one thing to say. The founding fathers wanted us to have a democracy. What is a democracy? We have had now, at this distance of time, 70 years from 1950. What do we find? We have changed governments with a ballot, not the bullet. Even emergency. Mrs. Gandhi imposed emergency, but in 77, she realized it is unsustainable in India and she withdrew it, called for elections and lost. Strength of Indian democracy. You have a completely free press. In fact, I always say these online portals which day in and day out abuse the government for muzzling voices. I always say, but your voice is being heard, right? Very loudly, you're telling the whole world that your voice is being muzzled. I don't think it's being muzzled. Muzzled voices are those which are never heard. Somebody screaming saying you're muzzling somebody else's voice shows that you're not muzzling voices. So we have by and large a free press. And we have a completely independent judiciary. At times you may not be happy with what they do, but then that's the very nature of the game. But we have a completely free judiciary. So these three big pillars of the constitution we have fulfilled, and I think we have kept our tryst with destiny. Yes, there is a lot to repair in the Indian democracy, but I think your generation, my generation, in fact, has failed Indian democracy. Your generation will do much better, and with you, I will only share in closing something which my guru, Mr. Palkhiwala, used to always say. Always remember, democracy is a ceaseless endeavor. It is not a safe harbor. Thank you.
Thank you, sir, for the extremely brilliant and wonderful piece of relation. Um, to give the audience the benefit of repetition, I would just summarize and briefly sketch out the provisions on which Sir touched upon. Sir began by dwelling into history and talking about the history of Indian constitutional system by stating that India adopted in governance a Westminster model, yet the Indian democracy has adopted a judiciary that is integrated and unified. Sir then talked about the specific Indian judicial history of the first, second, and third judges' case and stated on their facts. And then Sir came to the poignant problem of the pendency. And Sir, addressing it as a demand versus supply problem, has stated that the number of judges in India is abysmally low, chiefly owing to the problem that their salaries are unsustainable. Sir also pointed out that government is the single largest litigant in most of the cases, which also stalls the judicial process to a large extent. Sir called a solution by talking about the necessity of arbitration and alternate dispute resolution mechanisms. Sir then talked about the two deep blots on Indian judiciary, one being the emergency judgment and the second being the press conference of the judges. Sir then talked about the course correction that every institution that faces and the judiciary now faces. Sir then talked about the unanimous and brave gesture of the Supreme Court in delivering the Ram Janambhoomi case. And then Sir talked of the three pillars of the press, the judiciary, and the civil society in helping the judiciary find its true course. Thank you, sir, for the wonderful piece of speech. I would now like to open the floor for questions. The audience is requested to keep their mics muted and yet pose the questions on the chat box. Those who are joining us via YouTube and Facebook are requested to send in their questions via their respective chat boxes, which will be sent in here by the webmaster. Sir, we would be beginning with the moderator questions, which me and Naitik will be asking you, followed by preset questions, which we have sourced from a Google form that was widely circulated, followed by the audience questions. I would request Naitik to go ahead with the first moderator question.
Right. Thank you, sir. Thank you so much for the insightful lecture, and it was, so to say, thought provoking, and to say the least. So my question would be regarding there's a phrase, if I am not stating it wrong, that jail is the exception and bail is the norm, usually. So, is the Indian judiciary going more towards or tilting more towards like giving custodies and keeping people inside on pretexts which might not be as as credible as uh, they were used to be before, maybe? And the second question, the addendum to this or the follow-up to this would be that is it that judiciary is coming under a lot of public scrutiny and what I call the public gaze? So is it a combination of these, or maybe the judiciary is actually tilting towards, uh, let's say, moving away from the the norm that bail is the norm and jail is the exception?
We have moved a long distance from the salutary principle. And I repeat, the salutary principle, the only principle consistent with the Indian rule of law and constitution, bail and not jail. Why have we moved away from that? Because we have, and this is by itself a full topic for a debate someday, we have moved into an era of instant justice. 1,000+ electronic channels who have to give breaking news 5 times a day. There is not as much news as there are channels and breaking news. Second, we have therefore mortgaged our brains to that little screen, which creates demons and slays demons. And especially the have and have not problem, where anybody committing an economic crime is first of all immediately demonized. And then we want instant justice. Now, how is instant justice served? Raid, a selective leak by the investigator, arrest, jail. Bail denied, your reputation is damned. On the small screen, you are tried that very evening. The anchor is your prosecutor, the 5 panelists, your jurors, and you are convicted. And if the court grants you bail, that is flawed, and you are sent inside. The courts have come under this. I'm sorry to say. The courts also have fallen prey to this mindset. Oh, people who are guilty of big economic crimes should not be given bail. Why not? They are citizens. Whatever may be the nature of your crime, whether you... The exception made by our law is somebody guilty of a violent crime, and bail was to be denied because if somebody has a tendency to violent crime, allowing him to be in society, he may repeat that crime, he may try and wipe out evidence. Today, where evidence is all electronic paper trails, where a proper investigation is being done, where you have the kind of powers of freeze and search and seizure which you have, why should you keep somebody in jail till charges are framed 4 months later? Is it only to feed our sense of instant revenge? And that is where we have gone wrong. From trial, we have gone to a completely different criminal justice system where you are punished by embarrassment and denial of bail. That very evening, you're found guilty on a TV channel. Next day, you're put inside a jail and everybody forgets about it. Look at what has happened in the 2G case. 100% acquittal. Everybody has been acquitted. That judge wrote that I was sitting in this court waiting for one shred of powerful evidence. It didn't show up. But what happened in the meanwhile? People in public life sent to jail, business people sent to jail. I know of business people, a chartered accountant who was a professional CEO in a company, sent to jail for 6 months What practice will he have after coming out? And will the system apologize to him? Or were we so happy about screaming about 2G accused sent to jail? Cheers, Indian justice has won. Doesn't matter if 2 years later everybody's acquitted. So this is a very major flaw which has crept into our system. These 1,000 electronic TV screens, channels, are driving the agenda of governance. We have to seize back so that they only give us news, they don't create news. Today they are creating news.
Right. Thank you, sir. My first question to you is with regards to the office of the Chief Justice of India. Currently, it is regarded that the office of the Chief Justice of India is heading both the judicial side as well as the administrative side of the Supreme Court, with the administrative side giving the Chief Justice the power to decide on the benches. Now, for time and again, we have observed that all the judges of the Supreme Court of India are equals, and the Chief Justice of India is the first amongst equals. So, does the provision of administrative head, or does the provision of being the administrative head of the Supreme Court distort this or create a disturbance in this principle of first amongst these equals?
Not at all. And let's be clear about a few basics. Every Supreme Court judge has the same judicial power. And no Supreme Court judge should have any interest in deciding a case. So no Supreme Court judge should ever feel a sense of disgruntlement if he is not put on a case. There are all kinds of judges. When they sit together in their judges' meeting, if one of them is not behaving properly, it is for them to sort that out. It is a team with a captain at the head, and that captain has to decide who goes into bat. No other system will work. Take it from me, no other system will work. We have to select the best as our judges. We trust them with our lives. They are the ones who can send us to the gallows. They decide the destiny of governments. They can remove prime ministers and presidents. Surely you trust them enough to decide who sits in which bench?
Thank you, sir. My question would be something I heard you said in an interview regarding the post-liberalization courts. Uh, in 1991, we all know, for the benefit of the audience, we all we went to the liberalization in economics, and I'm a student of economics. I find courts now and then giving price caps, giving trying to change market outcomes. Rather, I'll say private market outcomes. In that sense, would you say, sir, that the Indian court has successfully transformed from, I would say, the Nehruvian socialist mindset to a more, let's say, free market society based mindset?
It hasn't. Your point is very well made. There are still judges who view with a grave degree of suspicion anything which doesn't fit into the socialist mold. Let me give you a classic example. In the 2G case, a bench of 2 judges hold that natural resources can only be given by auction, other than to government undertakings. What did the petitioner achieve? The ultimate leftist agenda. You're back with public sector. Because if you are to run a steel plant at competitive prices, you cannot compete with the market trader who's going to buy the mine. If today you want to encourage somebody to set up a nuclear power plant with its extremely high cost, you may have to give a free mine with it to make it lucrative. There are so many different molds. It required a bench of 5 judges in the reference, in the constitutional reference, required a bench of 5 judges to say that revenue maximization is not the only constitutionally permissible principle for the government. You may have so many other priorities. So it is very important. Today also, in so many times, today for a lot of judges, profit is still a bad word. Judges have not come to terms. I was in fact speaking about this when you talk of socialism and why I am a staunch critic of introducing the word socialism into the constitution. Look at today's world. In the country in which I now live for a very large part of my life, UK, you have gigantic companies. Who owns them? Nobody. There are 5 private equity funds which own shares. Whose money do these private equity funds and do these banks and insurance companies put in? Your and my money. The savings are in the hands of extremely efficient fund managers who invest. And today, capital chases highest profit. But that return comes back to you and me in higher returns on our pension funds and higher returns on our investments. Now, where's the socialism in this? Can you say that you and I should give up our return because some laborers have to be paid more? And which side must the balance lie? So look at what is going on today in India. I'll give you a classic example. On the one side, you have flat buyers who do not have money to pay EMI, correct? Because of the lockdown, people have lost revenues. There the money goes to the real estate company who therefore is broke because the revenue stream goes away. They are unable to pay the non-banking financial companies. The non-banking financial companies then cannot pay interest on the non-convertible debentures by the mutual fund managers. But the mutual fund managers then can't pay the poor pensioner and the middle class person who has invested his money. So on both sides, you have the common man and you have a chain of financial intermediaries. This is a very different picture from when we spoke of socialism about this rich fellow whose grandfather was a former Maharaja and he had the money and from where he set up, or he was a beneficiary of British benevolence and he set up a big factory. And from that factory, this rich Seth used to come in his Chevrolet car, a la Bollywood style, and have the poor workers, and therefore the state had to intervene. And those days are gone. Today, look at India's largest company, Reliance. What has happened today? Aramco's invested. You heard about that. And the big Facebook is investing so many $1 billion. And then you heard that the 3 big private equity funds are investing so many $1 billion. And now you heard the Abu Dhabi government investing so many $1 billion. So what's going to happen to the management of Reliance? It will be institutionalized. It's no longer now a company in which the promoter has the sole voice. It never was. I mean, in any case, corporate governance requires you to have independent directors. Now, each of these will want their own directors, will want their slice of management. Where is socialism in all this? Where is socialism in all this? So, these private equity funds who are investing, whose money are they investing? Middle class investors, which is lying with them in developing markets, they are investing because they find it a blue chip investment. So, see, this socialism has created a lot of problems. Now, this understanding of the new world, which you see so completely absorbed in the American courts, you see it understood in the UK courts. This full understanding of the new commerce has yet to come into the Indian courts.
Before Aditya goes ahead with the next question, a small brief follow-up, sir. Judges usually have qualifications in law, and and also lawyers argue according to the law, and judges dispense justice according to the law. But do we have a problem of grassroots experience with the judges in India? And also domain expertise, sir.
You raised a very sensitive issue, but let's address it today. Look at why the UK has reached a point where one of its major income or an important income source is rendering services, legal services. Why has it become an international hub of dispute resolution? From the days where you saw Witness for the Prosecution, the old Agatha Christie based movie, where you had this eminent QC who would do a tax case and who would do a criminal case, you now have specialized lawyers and specialized courts. So you have the construction court, you have the commercial court, you have the family court, you have the court of equity. These are the courts of first instance. To be normally, judges are selected with qualifications in mind. So for the commercial court, they will normally take somebody who's been an engineer who has then become a lawyer and drifted in, an MBA, or so and so. So when we suggested this model for the Indian commercial court, and we have commercial courts in India, I had in fact suggested you must have selection in the High Court, but you must pay an extra allowance for a judge who's an MBA, for a judge who's an engineer, for a judge who's done banking, and put them in your commercial court. And then these judges will gradually, after 10 years, be in the Supreme Court. So the domain expertise then gets carried to the Supreme Court. This is very important in India. Justice Kapadia, late Chief Justice Kapadia used to speak about that. Regulators. And I said this in a recent webinar. We need to hit post-pandemic. We need to hit what I call reset India. See how we have come together as a nation in the lockdown. This lockdown was based upon a trust between the government and the people. Let's carry this forward. Why to have a regulator on the real estate? Why couldn't you not have a retired chairman of a real estate company? Who will understand real estate business better than him? Who will not see through nonsense being told by somebody? A retired chairman of an insurance company as the insurance regulator head. Why must it always be a retired judge or a retired civil servant who completely lack domain knowledge? So we need to start trusting our people. In England, the first competition commission equivalent was called the Panel on Takeovers and Mergers. It was an industry panel, blessed by the government. So for the press in India, we had suggested, and this model is in place, and for quite a while it worked well. For the electronic media, we said you must have a regulatory board appointed by the media of media people, jury of your own peers. So this domain knowledge is very important, and this is one very important reform which is crying out loud. And if Indian commercial courts, what have we done? We have done, Mr. Palkhiwala used to always say India is a land of gestures. So what have we done? We have changed the naam ki patti outside our courts and called them commercial courts. At least in Delhi High Court, Justice Gogoi, when he was Chief Justice, he started this PIL. He requested me to help. I took literally the English Commercial Court Code and wrote it out with suitable adaptations. And Delhi High Court Commercial Court has adopted it. We persuaded the lawyers to agree to fast-track commercial trials. But you need dedicated commercial court judges and judges with domain experience. And believe me, otherwise sometimes you have real howlers coming out of the commercial court.
Great. Thank you, sir. My question to you relates to the answer that you have given on the borderline. On the role of technology that courts need to employ. The Economic Survey previously has called up for the courts to employ professional managers to handle courts' business and to dispense justice faster. Few have also suggested the employing of artificial intelligence and machine learning in order to give you an instance. Few have suggested that we might use machine intelligence to construct an algorithm to determine which judge sits on which case. So how sustainable do you think, or how efficient do you think this attempt, or in particular the suitability of machine learning algorithms, or in general the efficiency of professionals for the court business would do?
See, this is what I'm telling you. Trouble is in India, everything has to grab headlines. 4 judges had a press conference, so we start looking for an algorithm to find which judge must sit on which bench. That's not where Indian justice delivery system is stuck. Please understand, for the average Indian, his interface is with the district magistrate or with the subordinate judge or with the district judge. Correct? 70% of the average Indian's problems are in the subordinate judiciary. The balance 20% are in the High Court, Supreme Court, hardly any. So let's try focusing on getting those systems to work. If district judges have computerization, which helps all files, the way it is done in the High Court, you get your board delivered to you on a pen drive. You have a laptop, you can read everything. It takes you 2 hours in the morning, you make notes, you have judgments readily available to you. Everything is transparent. And court proceedings should be webcast. Why must you have crowds inside the courtroom? I should be able to sit in my living room and watch what's going on in court. I'm not asking for TV broadcast, I'm asking for a webcast. It happens in the US. In the UK, they've started it. For very important hearings in the Supreme Court, they webcast the proceedings. And certain newspapers have reporters sitting there who are giving you a transcript word by word. When the Brexit case was being argued, you could hear the transcript word by word as to what is being said in court. So these are the kind of systems, plus judges, witnesses, so many times old witnesses. And there is a formal witness who has to produce documents. That civil servant should sit in his office and say, yes, I've sent this file and this file is so and so, in 10 minutes it's over. So there's so much you can do by the means of electronics. Sorting out cases, searching cases, bunching of cases, mixing of jurisdictions, finding which cases should be heard when, the diary management, all this can be a huge help. But let us, for God's sake, let us try making the work of the subordinate judge easier. Let us try giving him a better environment to work, a clean courtroom, an air-conditioned courtroom and warm climes, access to technology, access to communications methods. Let's get that going. Do you know how it works here in the commercial court? The judge's secretary sends you an email. You reply on an email. You send them, by the way, tomorrow the judge is hearing a case. There are 2 more judgments I want to cite. I'm attaching them to this email. I've taken the liberty of yellow marking the paras I want him to read. Please show it to the judge. When he comes to court, he says, yes, I've read it. Yes, make your point. You saved 1 hour of reading a judgment. So this is how you speed up the process, not by doing dramatic headline grabbing things like a computer will fix who sits on which bench and then let all of them struggle with the rest. That's not how we do it.
Right. We have a couple of preset questions and a lot of audience question about totaling to 20, but we cannot, I think, take those many. Right. So, and we have a lot of them here. So, sir, we'll take questions in about 2 bunches and then you can answer bunch by bunch. We have about 15 minutes or so. Is that good, sir?
That's fine.
Right. Okay, so we'll take 2 bunches of questions directly from the audience. We have the first bunch of questions. We have Pranav Garg, Sangam Ekka, and Siddhant Bagaria. So can I ask Pranav Garg to unmute and go ahead briefly with your question? We have Pranav Garg. Okay, your mic is not working. All right, all right. I'll just read out your question, Pranav. Then, till I go to Pranav's question, can we have Sangam Ekka unmute themselves and go ahead with the question?
Yeah. Hello. Is there audio?
Please go ahead.
Yeah. Hello, sir. Good evening, sir. My question is that, with regards to Ram Janmabhoomi case, sir, as you mentioned, that was a brave and balanced judgment, sir. But do you think that some of the judgments which affect public sentiment, on that cases, courts tend to lenient towards that, as many people often say that if the case would be against Hindu sentiments, the court had to alter it, or government would by passing any ordinance. So, if any full majority government comes into the power, in what way it affects the justice system or processing of courts? So how could that affect?
Okay.
Uh, let's take
So can
let's
we
take
take
the
two or
second.
three questions? Yeah,
Sure.
right. So we have Pranav Garg's question on nepotism as a factor in the appointment of Supreme Court judges. We had Sangam Ekka's question on the Ram Janmabhoomi case. We have Pranav Garg's question who asks about nepotism factor in the appointment of the judges on the Supreme Court of India, and perhaps if I'm getting right, the other courts as well, maybe. And can we have Siddhant Bagadia unmute themselves and go ahead with the question?
Hello, sir. Yeah, so Mike, sir, as you talked about the courts and deciding the right time to pick up a particular controversy with respect to everything that's happening around in the country. So, in the context of the Indian judiciary, I would like to ask that considering the anti-CA protests and a lot of people getting charged under them, what should be or what would have been the right time for the Indian judiciary to pick up the sensitive issue of the sedition law in the Indian Penal Code, and what to do about it?
Yeah, sir, if you could take these three and then we take the last set of questions.
Sure. Let me take the first question first, and it's one of the issues which again calls for a full debate: majority government versus courts. In every system, the constitutional court and the elected government has a relationship which keeps evolving. It's nothing new. If you go back to the post-depression legislation in the US, the economic measures brought in by the US government were struck down by the courts, including the very famous, they had brought a tax on companies which was struck down. And it's a famous story that the president of the US only threatened to pack the judiciary. And he says, if I have to pack the judiciary, I will. But we cannot have the judiciary standing as a roadblock in the way of bringing much needed economic reforms to the depression's effect was massive, the post-war depression. And as the story goes, the New Deal legislation, as it was called, Roosevelt's New Deal legislation, he didn't have to pack the judiciary, but the Supreme Court altered course and upheld all the other laws on the New Deal legislation, virtually overruling some of its earlier judgments. So this is always an evolving position. In India, it's very interesting what has happened. The pre-emergency Supreme Court was a bold court. First, till 1973, the Keswanand Bharti case. The Indian Supreme Court's problems with the government were on property laws. First came the property laws, which were unquestionably right. The laws which destroyed the feudal backbone of India. They were called for, they had to be done. And to a feudal measure, you cannot say you must give 1 rupee compensation for 1 rupee right taken away, because then you're only recycling feudalism. In 1969 bank nationalization, the Supreme Court was right when it said if you take away the share of somebody in a bank, you have to pay him market value. Mrs. Gandhi's left-leaning politics got upset. That was the background for Keswanand Bharti when they amended Article 31. And interestingly, in Keswanand Bharti, the Supreme Court upheld that property is not a part of basic structure. All the laws were upheld, which took away the property rights from the Indian Constitution. A blunder, according to me, but anyway. But the Supreme Court put a marker saying you will not amend the basic structure of the Constitution. And see the wisdom of the judges who laid that down. In 1975, the absurd, in fact, the diabolic constitutional amendments which were brought, which put the president and the prime minister beyond law. If you became prime minister, you couldn't be convicted of murder. Nonsensical amendments like that, which in 2020, people of your age cannot even conceive of, were actually passed in India. We have to remind ourselves that was passed. And the basic structure doctrine was used in 75, Rajnarayan versus Michigan, to strike down those absurd laws. So basic structure was born in that. And the government of that day was a powerful majoritarian government which said, we will fix the Supreme Court. So in 73, the three senior most judges were superseded. Justice Scheller, Justice Hegde, Justice Grover, and it dropped straight to Justice A.N. Ray to become the Chief Justice. And then came Justice Khanna, whose dissent has now been cited with approval. Khanna's dissent there matches Justice Lord Atkins' dissent in Leverage and Anderson. Justice Khanna, who stood up, and Justice Khanna actually was the middle voice in Keswan and Bharti, which laid down the law for basic structure. So he had to be shown the door, and he was shown the door in 1977. And that has been one of the blots on our constitution. But that is what happens when you have a large court and a large government. After which, post 1980, the court shrank. And we had leftist judges who pursued socialism. But post-emergency, the court also struggled to find its identity. And then we had what is called the Krishnaization of Indian jurisprudence, where the court opened up its doors, it started dealing with citizens' problems, the court reinvented itself. It went on all very well till 1990. And then what happened post-90? The judges' case, the Jain Hawala case, you had a government which shrank. Coalition government shrank. The power of the court increased. I have this theory. I say nature abhors a vacuum. So when government shrinks, courts expand. You saw the maximum expansion between 2009 and 2014 in Manmohan Singh's government. The court completely expanded its power. Virtually, the court was running the country and ordering inquiries against all and sundry, court-monitored investigation into this, court-monitored investigation into that. There were a handful of people who used to bring petitions to Supreme Court and were running India. Comes a government with a full majority, there had to be a course correction. So this is an evolving balance. There is nothing wrong. These are institutional mechanisms which correct themselves. You today have a government which has the majority, which has the support of people, and say, these are our economic policy, these are our social policies. This falls within the remit of the executive, and we have a right to administer the country. And the court, in one sense, backs off and says, all right, we acknowledge this is your domain, we step back. As long as you have a powerful government, powerful in the sense, an effective government, not a fractured coalition, who's taking the decisions, it's their call. They will pay for it in the next elections if they get it wrong. So this is a evolving mechanism. This is a self-corrective mechanism. So that is the relationship between majority and courts. Nepotism. Is there nepotism in appointment? If I say no, you are not going to believe me. Why? Because the system is such that it lacks transparency. Now, transparency of the kind proposed in Supreme Court is not going to work. Please imagine what's going to happen. If you say, give your reasons for every appointment and every refusal to appoint, suddenly you will have on the website of the Supreme Court, 15 names came from the High Court of Mr. A, B, C, D, E, F, G, H. We have appointed A, B, C, D, E, F, G, H. We find not worthy to be a High Court judge. You've damned his reputation. That person will say, I didn't even know. Sorry, what inquiries did you make behind my back? It's very unfair. If you give reasons for transfer of a judge and say we have serious complaints of corruption, do you want to read about that? What happens to the man's reputation? So this system can't work. And you have a system which is completely opaque. You need a National Judicial Appointments Commission, which has a proper system by which they receive applications for judgeship, they invite applications for judgeship, and they process those applications. And whose decision can be questioned? Today, when you are telling a Supreme Court judge you're guilty of nepotism, how do I trust a man with a case if I think that that man can be, in a case, a person given to nepotism? Can I trust him with my case? I can't. And that is why the court has to step out of this space. The third, timing to take on CAA. The court has taken it on. They are going to decide it. Sedition law, they are going to decide if a proper case comes to them. But believe me, there are not that many sedition cases to decide. So these are all, and a lot of these which come in as a package of a political activity, sometimes are best given a little time to simmer down. And it disappears. I'll tell you one of the cases. I don't want to give you any details. One of the river disputes, he suggested a way out. I was advising one of the two state governments. That way out was followed. And we got a case filed in Supreme Court, and it kept pending there for 10 years, and both sides used to say, let it lie. Till the case is lying there, everything is quiet. If this case gets decided, we'll have trouble. So timing is also a little important in when you decide certain controversies.
Thank you, sir. For the final set of questions, we have Siddharth Kaushik, Raghav Khanna, and Sumit Singh. Siddharth Kaushik, can you please unmute yourself and go ahead with your question?
Yes, good evening, sir. So my question is related to the increased use of judicial activism in our country in the past few years. As we have seen that recently the Supreme Court has established a highly activist role, which has been seen defining various methods in which laws should be laid down and the ways in which the executive should carry out its policies. Do you think this role that the Supreme Court has attained is democratic in nature, and what does the future hold for judicial activism in India?
You asked a very interesting question. Can you hear me?
Apologies to interrupt you, but if we could have two more questions.
Yeah, sure.
As a
okay.
Yeah.
Right.
Raghav Khanna, can you please unmute yourself and go ahead with your question?
Yeah, hello. Yeah, good evening, sir. My question is, can arbitration be successfully executed in power struggles of the center and state? And my second question will be, is it okay for the ex-Chief Justice of India to be appointed as member of
Can we
Parliament?
limit the one person, one question? I'm really sorry to interrupt you, sir. We have a lot of questions and we have taken only a few. So if you could limit yourself to one question, sir.
All right. So I would like sir to answer my first question.
Thank you so much.
Thank you. We now have Sumit Singh. Sumit, can you please unmute yourself and go ahead with your question?
Hello, sir. My question to you is that what's your take on the capital punishment? Because after Nirbhaya case verdict, we have seen many human rights organizations and activists wanting death penalty to be removed from India. I would like to hear your comments on this, sir.
Judicial activism. Let me take the first question first very quickly. Somehow I'm a little concerned about using this phrase judicial activism because it has some very strange connotations and which are indefinite. So let's focus on it. Yes, the Supreme Court opening up its doors to causes and not people. What do we mean by that? Earlier, the court, if a case came before it, would ask, who are you? How are you concerned with this? How does it affect you? That is called deciding causes brought by people who have locus standi, who have the standing to bring the cause. The Supreme Court widened its doors to say, we will look at the cause and not the person espousing it, as long as he is a bona fide person. So that is what the court did. It then started taking on causes. And there have been times where the court has strayed into areas where they shouldn't have. The time is now where the court is correcting its course. So yes, there have been times where the Supreme Court has strayed into areas which were areas of governance. But then again, it sort of pedals back into the previous question which I spoke about, and I don't want to repeat it because of shortage of time, about government shrinking and judicial scope expanding, governments expanding and judicial scope sinking, because if there is a government in place which is taking decisions. But let me just mention one thing. As lawyers, as citizens, we may complain of a overreach by the judiciary. The governments dare not. And I always say the governments dare not for the people, because there are times when the government has invited this trouble. When the Attorney General for India in 1992 December stood up and told the Supreme Court, the forces are in Ayodhya, my lord, they are waiting for your lordship's orders. Justice Venkat Chalaya told him, the forces have to be commanded and ordered by your generals, not by Supreme Court judges. Why did they want the Supreme Court judges to direct firing in Ayodhya? Because they didn't. They wanted the judges to be blamed if Hindus are killed. At every difficult place, you say, we leave it to your lordships to decide. Why? Controversial decision, let the judges decide. This was the hallmark of coalition politics in India. And that is why, if you are inviting the court to decide these issues, then you can't tell them which ones they should decide and which ones they shouldn't decide. Then they will go deciding other things. So this was the problem with judicial activism. This is the course correction which is now happening, because now you have a government which takes on and decides whatever it thinks is right. Arbitration between center and state is a wonderful idea. It requires a change in mindset. In fact, center and state disputes should be resolved by arbitration, as it is done in so many jurisdictions. Should be resolved by arbitration, but as long as we have the political maturity to accept, as we always say, the best decision is one in which both sides go equally dissatisfied. Then you know you've hit the right spot. We must have the political maturity to decide this. Capital punishment. In the context of the Nirbhaya case, I've always been of the view that India again becomes a land of gestures at times. When the Nirbhaya tragedy happened, we did not improve the surveillance in our cities. And I will share with you something. At the time when that was going on, one private company wrote to the government saying, we will install a few thousand CCTVs on the streets of Delhi, where if you allow us to put those poles, we will expand our business. They were in the business of telecom, but we will give you a free CCTV, the feed of which will go direct to the Delhi police headquarters. And on the file was a noting saying, we have enough surveillance on our streets, we don't need any more. So that is what we need to fix. Believe me, you can say death penalty, you can say, I will hang you twice, I will not hang you once. A person who has that criminal bent of mind and is committing the crime, which is now established, is not really deterred by the punishment. So if you say instead of 7 years, make it 12 years, make it 14 years, it's not that a rapist is going to say, oh my God, up to 7 years, I was willing to sit in jail. Or up to 10 years, I was willing to sit in jail, but for 14 years, I won't sit in jail. So that's not how criminology works. But for us, it's a gesture. So, oh my God, something like this has happened. We will increase this punishment, increase that punishment, and all the hoo-halla on our electronic channels dies out. Capital punishment's existence has to be determined, de-linked from all this. And believe me, till the scourge of terrorism is with us, you cannot do away with capital punishment.
Right. Thank you so much, sir. I think that would be it. We had more than 20 questions right now, but it's difficult to take them all. And again, I'd quote you again. You said a Marathi phrase. I hail from Nagpur, your hometown, and you said about a Marathi phrase. I think that rings true here. About tail kadun ghene. I think we did a lot of that today, and we have already bugged you a lot till now. It's been more than
when I joined Soli's chamber,
yeah.
He said, "Me tail kadin tuza." I had only told him, "Sir, pushkar tail I kadita kadayase."
Yeah, आज पण तेच झालं, I guess. I think the same. Like we have been continuing with questions, and we have requests on the chat box. Ki please, we want to ask a question. But I think here is where we go ahead and conclude today's lecture. Thank you so much, sir. I want to call upon our Madam Principal, Dr. Srivastava, to please conclude today's address, ma'am.
Ma'am, we can't hear you. Can you please unmute yourself?
Oh, I'm so sorry. Okay, thanks, Aditya. Thank you, Natik, and Salve, sir, Mr. Harish Salve. Although I joined little late, I could not attend the beginning because of some earlier commitment of a webinar, and I therefore did miss the initial bit. But thank you so much, sir. In the outset, I would like to say this, that we could manage to have you thanks to this current situation of crisis. But it's been such a huge privilege. It's a huge opportunity that the students and scholars and alumni and teachers who are, I'm sure, attending this webinar today, they have got such beautiful insight of the judicial system. Thanks to you, sir. You've taken out time from sitting there in London, and I'm sure that you've been getting several other offers, but you have accepted this one as a major motivation for our students. And yeah, I'm sure you, with the questions, I don't know how well you would rate the questions, but I think they have done quite a good oh, I'm so happy to see this gesture, sir. So nice. So that's really very, very motivating for the students. And I would say that you've taken so many aspects of the judiciary system that so many students would be quite motivated to look into this and, taking it up as whatever future when they're going for exams, this, that. I'm sure they have your impactful talk today in their mind whenever they go. So speakers like you give a lasting effect of what has been conveyed by you. And sir, I'm sure you would be knowing that this college is known for having several alumni who are into this judiciary service or the legal services. Some of the top brass are from this college, and yet we have not really had so many interactions with the judges or people of your stature. So it's been a real delight, and I hope that we are able to have you more often, even if it is like this. I think now this is the new way of interacting. I think that way suits everybody. The speaker and the organizers also are happy with this. And whatever little I could, I mean, for us also it's a new thing, but I mean, absolutely needless to say, in every system, understanding of law has become almost indispensable. It is one very important part of any organization nowadays, because everything, as you said in your talk, is being shoved into the judiciary system, that kuch nahi hota to court mein settle karenge. So that is sad, but that's the way things are going. And as you pointed out, that a lot of bottoms-up approach is required for setting out or redressing the lack of efficiency of the judicial system. I think with people like you there, we are sure things can be improved. And yes, at the top level, things have improved in terms of digitization, in terms of having the cases, etc., available on the net. Those kind of facilities have been definitely brought into existence, and I'm sure people are gaining out of it. But what is required more is at the lower level, where there are huge number of litigants and they are actually facing the wrath of it. So, and other students have given up many aspects, from Ram Janmabhoomi to capital punishments to whatnot. So I think it's overall for us, it's a great learning experience, very enriching for all of us. And thank you so much once again, sir, for taking out your time. And I'm sure the students should keep in touch with sir. And also we would like to have
you must.
Physical form also sometime, whenever possible, whenever there are some other days that we can see. Thanks a ton, sir.
Then on that note, we conclude today's lecture. We thank you all for joining us via Zoom, Facebook, and YouTube. Facebook, YouTube, and Zoom, right? And we hope to host sir sometime very soon in Hindu College. Thank you for joining us. You'll find the transcripts very soon on caucusdiscussions.wordpress.com. And we also thank Divya ma'am for helping us, and we'll get in touch with her very soon, maybe again to call sir, perhaps for a discussion. And
delighted.
Right. So on that note, then bye for now. We'll be back shortly with another speaker. Thank you so much. Bye from Caucus.
Thank you very much once again, sir.
Oh.